Good afternoon, all, and today's video is on the topic of Florida's squatter statute, the residential squatter statute, Florida statute, section 82.036. Now, these squatter statutes in Florida, they are, and they're proliferating across many states now. They are, in a nutshell, a political reaction to the illegal migrant problem in the United States, and in this case, in the state of Florida. These statutes are a knee-jerk reaction that haven't been thought out very well. So, to begin with, let's look at the statute. The statute is captioned Limited Alternative Remedy to Remove Unauthorized Persons from Residential Real Property. It does not say that a vendor-seller of real property of an agricultural horse farm with a residential dwelling on it, with barns and sheds and a horse facility, can remove his equitable owner property purchasers from their property. So that's the first thing right off the bat. The second thing to notice is the statute itself goes out of its way to provide the actual squatter complaint form to the person signing it, gives that person substantial help by directing what the person is to file, how they are to file it, and where to take it. But as we see, there is no equally available form for the victim of one of these how to contest it, and instructions of exactly what to do to contest it if you believe this complaint has been wrongful or wrongfully executed or has perjury on its face. Now, this statute says a person may bring a civil cause of action for wrongful removal under this section. A person harmed by a wrongful removal under this section may be restored to possession of the real property and recover actual costs and damages incurred, statutory damages equal to triple the fair market rent of the dwelling, court costs and reasonable attorney fees. The court shall advance the cause on its calendar. That's what it says. So, to be clear, Florida's squatter statute does not give the victim a pre-deprivation judicial hearing, a court hearing, before the person is walked off the property. Instantly walked off the property when the sheriffs arrive in their sheriff's squad cars with no prior notice. So, if the victim does not get a pre-deprivation hearing, which is ordinarily a due process requirement of due process of law under the 14th Amendment to the United States Constitution, then the only way a statute like this could even possibly be constitutional would be if the person were given a timely and expedited post-deprivation due process hearing. And so that was the idea of the Florida legislature when it drafted the squatter statute. Now, the state of Florida enacted and signed into law the squatter statute after the state of Florida had already had a similar statute that did not even go as far as the squatter statute, struck down by the United States Supreme Court in Fuentes v. Shevin, and that's the case here. The primary holding of the case was, even if the government deprives an individual of property only temporarily, due process requires notice and an opportunity to be heard. So, how is the fact pattern in Fuentes v. Shevin similar to the squatter statute, this newfangled experimental squatter statute Florida enacted? Well, Fuentes had bought a stove and a stereotype from a store, Firestone Tire and Rubber Company. And the seller, Firestone, tried to replevin the stove and the stereo, that is, take it back. It argued that Fuentes had defaulted on her installment payments, but Fuentes was not served with the replevin complaint before the seller, Firestone Tire and Rubber, had the sheriff seize the stove and stereo based on a writ of replevin that the seller had received. So Florida state law had permitted the writ to issue without any convincing evidence that the goods, the property, had been wrongfully detained. Instead, sellers in Firestone's position only simply needed to file a complaint and post a bond before obtaining the writ. Once the property had been seized, parties in the position of Fuentes could get it back by posting bond, but otherwise they would need to wait until the hearing on the merits of the replevin claim. And so this is a similar situation where there was no pre-deprivation due process hearing before Fuentes' property was seized. And Fuentes argued that these rules violated due process. So a majority of the United States Supreme Court struck down Florida's statute. They stated the importance of notice and the right to be heard is an important check on the power of the government to deprive an individual of property, which is especially likely to be unfairly used when the government is acting on behalf of a private party. These due process protections must attach before the property is taken away, since later return of the property does not compensate for its temporary wrongful deprivation. Now, Pennsylvania had a similar replevin statute. So the United States Supreme Court held in Fuentes v. Shevin that the Florida and Pennsylvania replevin provisions are invalid under the 14th Amendment since they work a deprivation of property without due process of law by denying the right to a prior opportunity to be heard before chattels, i.e. the property, are taken from the possessor. Procedural due process in the context of these cases requires an opportunity for a hearing before the state authorizes its agents to seize property in the possession of a person upon the application of another. The possessory interest of the appellants, who had made substantial installment payments, was sufficient for them to invoke procedural due process safeguards, notwithstanding their lack of full title to the replevied goods. Okay, so Florida's experimental squatter statute does not require and provide the victims of one of these squatter complaints any prior judicial hearing or meaningful opportunity to be heard before the victim is walked off their real property. The statute does not say anywhere that it cannot be used by a property seller vendor against his property purchasers, especially those who have an equitable ownership interest. What it is it's a free-for-all. It encourages and invites seller-vendor predatory conduct and perjury and elderly exploitation. So, in sum, you don't get a prior court hearing. None. Zero. Zilch. Now, wrongful removal remedies do exist in the squatter statute. Commentary discussing Chapter 82 Florida statutes notes that a person wrongfully removed may pursue damages and other remedies. One constitutional question is whether a damages remedy months later is an adequate substitute when possession was immediately lost and no prompt hearing was provided. Many due process cases emphasize that when pre-deprivation process is limited or absent, such as Florida squatter statute, the availability of a prompt post-deprivation hearing becomes especially important. In Connecticut v. Dorr, the court struck down a statute authorizing attachment of real property without any prior notice or hearing. And that decision applies the balancing test of Matthews v. Eldridge. The risk of erroneous deprivation was a central concern. In North Florida Finishing Inc. v. Dichem Inc., the court invalidated a prejudgment garnishment procedure because it lacked adequate procedural protections, including meaningful judicial review and prompt opportunities to challenge the seizure. That case is frequently cited with Fuentes v. Shevin when arguing that ex parte deprivations require rapid judicial review. In United States v. James Daniel Good Real Property, the court held that absent extraordinary circumstances, the government generally must provide notice in a hearing before seizing real property. Getting back to the Florida-specific experimental squatter statute, Florida Statute 82.036, the statute itself provides a law enforcement removal process for allegedly unauthorized occupants. Critics have noted that the statute does not expressly create a dedicated, expedited judicial hearing procedure for the removed occupant. The omission is exactly where a procedural due process challenge would be directed under Matthews v. Eldridge, Fuentes v. Shevin, and Connecticut v. Dorr. So, I was in the barber shop a few days ago when an attorney for Three Rivers, that's a legal aid organization that helps people who need a lawyer, especially with being ousted of possession of real property. And the attorney and my husband and I were talking about Florida's experimental squatter statute. Now, first of all, I went to law school. My husband went to law school, and obviously Three Rivers' lawyer went to law school. In law school, it's drilled into you as a law student that when someone files a complaint, what you do is you file an answer, maybe affirmative defenses and counterclaims. So that's what we did. And Three Rivers' lawyer, without any prompting, said, well, you file an answer to the squatter complaint. Okay, that seems pretty reasonable. And you can't just say that my husband and I, because we went to law school but we are not lawyers, messed it all up by filing an answer in affirmative defenses and counterclaims to the squatter complaint. And so on the day that we filed our answer and motion to dismiss the squatter complaint, vacate it, and restore us to possession, we went to the Bradford County location of the 8th Judicial Circuit of Florida Circuit Court and brought in the answer, affirmative defenses, and counterclaims and attached the squatter complaint to it as an exhibit. Now, the clerk, the circuit clerk, and another clerk that was in the same office, because they have all sorts of division clerks in the same office, it's a small county, they didn't know what to do. I guess maybe they never had processed the squatter complaint before. They were all like, what is this? And trying to figure it out and looking at the statute. So the circuit clerk told me I had to file a civil action, write civil action over the top of the caption of my answer, affirmative defenses, and counterclaims. And then she filed it. So then what happened? Did we get our expedited hearing? We filed the answer and motion to dismiss and restore us to possession on April 22nd, 2026. The squatter complaint, the invalid squatter complaint by the property seller vendor against his property purchasers, equitable owners who clearly were authorized to be on the property, the complaint that contained perjury on its face, was executed by the Bradford County Sheriff on April 15th, 2026. So we were walked off the property, not only the residential dwelling, but the other 9.5 acres of the farm, the sheds, the horse areas, the fencing. They took over all 15 horses and ponies owned by the trust without any consent of the trust or order against the trust to do so. They did not serve the LLC conducting business on the property, Patrano Farm LLC, or the two special needs trusts, including the one that owned the horses. The LLC and the trust were not identified on the face of the complaint. They just took over, walked us off, walked me off in my underwear, no breast cancer medication, no social security card, no driver's license, no social security money card, no Medicare card, none of my identification documents, seized all the property of the LLC, the two trusts, our property, walked us off. No prior notice. So this is the judge who was assigned to our case about the squatter complaint. George M. Wright, Circuit Judge of the 8th Judicial Circuit of Florida, who was invested in January 2021. He is responsible for presiding over civil cases and ensuring proceedings comply with Florida law and judicial ethics. This is the judge, the Honorable George M. Wright. And this is him, the Honorable George M. Wright, in 2021 at his investiture, being given the oath of office by Monica Brasington. Now, according to Trellis Law, the Honorable George M. Wright was appointed to the bench by Governor Ron DeSantis in 2020. And he earned a JD from the University of Florida Frederick G. Levin College of Law in 2006. After graduating from law school, Wright began his legal career as a law clerk for the late Honorable Maurice M. Paul of the United States District Court for the Northern District of Florida, and served in that capacity until 2008, at which time he joined the office of the state attorney for the 8th Judicial Circuit as an assistant state attorney. So the Honorable George M. Wright appears to be very well qualified. We all hope that he is fair and impartial, and that he follows Florida law and the United States Constitution. And we have to turn to the orders he entered. This is the first order that Judge Wright entered. And he denied the emergency motion to dismiss, and he did not give us the statutorily required post-deprivation hearing. What he says is, this matter is before the court on defendant's emergency motion to dismiss squatter complaint. The defendant's motion seeks to argue the merits of the case regarding lawful ownership of the subject property. A motion to dismiss examines the legal sufficiency of the complaint, not factual determinations. And then Judge Wright cites two cases. A trial court, in reviewing a motion to dismiss, may not look beyond the four corners of a complaint and its attachments to take judicial notice of a separate legal proceeding. And he cites another case. Similarly, a court cannot consider matters outside the four corners of the complaint. A motion to dismiss should not be granted on the basis of defenses unless the defenses appear on the face of the pleading. Because the motion to dismiss asks the court to rule on the merits of the case, it is legally insufficient. Therefore, ordered and adjudged, the motion is denied. And it is signed by George Wright, Circuit Judge. Filed on April 23rd, 2026. Now, if a squatter complaint contains the statement that the person signing the squatter complaint, such as John M. Miller, as president of Bradford County Telegraph Incorporated, signs it making this statement that he understands that the statements made in the complaint are being made under penalty of perjury as provided in section 92.525 Florida statutes. What that means is if there's perjury on the face of the squatter complaint, then the victim should be able to raise that perjury, be restored to possession, and to have that post-deprivation hearing restoring to possession expedited and immediately. That's what the Due Process Clause requires. Now, Honorable George Wright's background stated he had worked for the state attorney's office. So he should have known that a perjury referral was mandatory. But what he did in this decision is if you can never go outside the four corners of the squatter complaint, then what Honorable George Wright did is he insulated every single Florida squatter complaint in the state of Florida from ever being examined for whether or not there was perjury on the face of the complaint. And if there's perjury on the face of the complaint, since it tracks the required elements of the squatter statute that all have to be met in order for any execution of the squatter complaint to be valid and not invalid and void, then you have to look at the perjury. So there's a problem right there. We did not get a post-deprivation hearing. Why would Judge Wright want to insulate squatter complaints from being investigated, challenged, or subject to a due process hearing on the basis of perjury? That's a fair question to ask. John Miller. Who is John Miller? John Milhouse Miller is the president of Bradford County Telegraph, Inc., who is the bare legal title holder of the horse farm he had the sheriff walk us off of with no notice And so far, more than 9 weeks later, no due process post-deprivation hearing whatsoever. Well, why would Judge Wright want to insulate John Miller from any kind of investigation, discovery, or public court hearing, due process hearing, that could hear and prove his use of perjury on the face of the squatter complaint he had the sheriff execute against us? Well, John Miller is one of the wealthiest people in Bradford County, Florida. And John Miller is a pillar of society. John Miller gives out college scholarships to high school students graduating from Bradford High School in Stark, Florida. He also makes mortgages to people. Is it possible some of these mortgages are made to sheriffs or judges? We don't know for sure. We still have that under investigation. But we can say he is one of the wealthiest men in Bradford County, Florida. He is a pillar of society, and he is the publisher and, as president of Bradford County Telegraph, Inc., the owner of the Bradford County Telegraph newspaper. This means that John Miller can publish newspaper articles that boost the reputations and careers of sheriffs and judges who work or sit in Bradford County, Florida's 8th Judicial Circuit of Florida courthouse location, or he can destroy such careers and reputations. Why? Because he is the editor of the Bradford County Telegraph newspaper. So, I cannot say for certainty why Judge Wright went out of his way to try to insulate all squatter complaints in the state of Florida from investigation and court due process hearings for perjury on the face of squatter complaints. But I do know that John Miller had 3 perjury statements on the face of his squatter complaint that he initiated against us, that he had to have known when he signed it that those statements were perjury, and that if we got a due process post-deprivation court hearing to challenge being walked off our horse farm based on his perjurious squatter complaint, John Miller could have been exposed for not only the perjury, but elderly exploitation of us, of my husband and I. And what would that mean? That would mean that anyone taking a mortgage from him and Bradford County Telegraph, Inc., or high school scholarships, college scholarships, might be taking, for lack of better words, blood money. That is money that John Miller accumulated from using perjury on the face of squatter complaints against his authorized property purchasers responsible for the intentional killing of my autism therapy service and trauma support horse and elderly exploitation. I'm not saying that is why Judge Wright went out of his way to shield John Miller from a due process post-deprivation court hearing that could have exposed his perjury and elderly financial exploitation. But this is what the appearances would suggest or might suggest, and it certainly would be a powerful motivation. So then we filed a motion for reconsideration and made some arguments. 20 minutes later, on May 4th, 2026, Honorable Judge George Wright entered an order closing file. We still had not gotten our due process required post-deprivation hearing after our real property was seized and taken from us with no notice and no pre-deprivation hearing. And he said the court finds as follows. No cause of action was filed in this case. Rather, the plaintiffs filed with the clerk a squatter's complaint that was served on them by the sheriff. The plaintiffs then filed an answer, affirmative defenses, and an emergency motion to dismiss the complaint they filed against themselves. And that was the motion to dismiss to vacate the squatter complaint to restore us to possession. It appears the plaintiffs are asking the court to rule on matters not properly before it. With no justiciable controversy, the court is in effect being asked to give an improper advisory opinion. The circuit court lacks jurisdiction to render declaratory relief in the absence of an actual controversy, and then cites a case. There are no pending motions in this case. Well, there was a motion to reconsider filed 20 minutes earlier that the judge ignored. No further judicial action is required. Therefore, the case is dismissed and shall be closed by the circuit court clerk. May 4th, 2026, and it's signed by Honorable George Wright, M. Wright, Circuit Judge. As purchaser equitable owners, we were walked off the real property we were purchasing by the vendor seller on April 15th, 2026. And the only remedy a vendor seller of property has against his purchaser equitable owner is within the exclusive jurisdiction of the circuit court in an ejectment proceeding, not a sheriff squatter complaint. So right off the bat, there's a problem. So they had the animal control without the consent of my special needs trust take over the 15 horses and ponies medically prescribed for my autism therapy service animals, and my 30-year-old horse Gulliver was also a trauma support companion, and he had been one of 28 years with me. They took these horses and ponies over on April 15, 2026. For the next 5 days, the evidence I have proves that they did not feed any of these horses and ponies hay, no alfalfa, no beet pulp. The water troughs were not filled and were empty. See the video about Beauty on about April 18th, 2026, I just posted. The starvation video of Gulliver was posted back around April 18th or 19th. Watch that video. Another video I posted about animal control shocking abuse shows before and after pictures of Gulliver and Cadence before being the starvation by Bradford County Animal Control and after the starvation and all the shocking algae in the water troughs, all sorts of other things that they did. So on April 23rd, when the Honorable George Wright entered his order that did not give us the due process required timely post-deprivation hearing, knowing there was no pre-deprivation due process hearing and no notice before we were walked off that property, he could have saved the life of my autism therapy service and trauma support horse Gulliver. Most likely, maybe. It wasn't a guarantee because the starvation was catastrophic under animal control's care and custody. But it would have been 2 days before animal control threw up their hands and said, we're not taking care of the horses and ponies anymore. Contact John Miller's attorney, Charles Daniel Sykes, and go back and take over their feeding, watering, and the care of the horses. 2 days earlier could have saved his life. But we did not get any hearing. So no hearing whatsoever. No hearing before the property seizure, no hearing after the property seizure. So then we had filed the motion for reconsideration. Oh, well, the day after Gulliver was intentionally killed and died of a horribly painful cecal volvulus that was caused by animal control starvation, then the Honorable George Wright entered the second order. Now, remember that the Three Rivers attorney who went to law school like my husband and I did had the same reaction to the squatter statute, file an answer to the squatter complaint. But Honorable George Wright ordered that he didn't have a jurisdiction because it would take a declaratory, obviously, to restore possession. It was non-justiciable, and that even though we are the victims of the squatter complaint, and the squatter complaint was signed by John Miller, and we answered it, we were suing ourselves. So, again, stonewalled with no post-deprivation hearing. So we have had no hearing at all. Now, what is today? Well, today's June 26th, 2026. So we are over 9 weeks later, 9 weeks, and we still have not gotten any post-deprivation due process hearing from anyone. We didn't get a pre-deprivation hearing. No hearing, no judicial court hearing at all, and they took our real property and our personal property, and they intentionally killed my 30-year-old, 28-year autism therapy service and trauma support companion horse Gulliver. And so, on May 12th, as an afterthought, the Honorable George Wright entered another order without any explanation denying our motion for reconsideration, where we laid out that we were entitled to have an expedited post-deprivation due process hearing, and we had not got one. He just denied it outright. So, ChatGPT AI has informed me through analysis and those cases that I mentioned earlier that we have a very strong constitutional argument that the Florida squatter statute as applied is unconstitutional because it failed to give a prompt and meaningful post-deprivation hearing. The U.S. Supreme Court procedural due process cases established the rule that when government authorizes a deprivation of property or possessory interest without a prior hearing, there generally must be strong safeguards, including a prompt post-deprivation opportunity to challenge the deprivation. And Florida squatter statute has no expressly created, dedicated, expedited judicial hearing procedure for the removed occupant. The delay itself may be important evidence going to procedural due process. Courts often evaluate not only whether a remedy theoretically exists, but whether it is available in a meaningful and timely manner. How long a delay is in a post-deprivation hearing becomes constitutionally problematic. It appears very relevant to the 9-week delay so far that has been inflicted on us. So it's a very serious situation because in this instance, the vendor seller, John M. Miller and Bradford County Telegraph, Inc., made false statements in the Florida statute section 82.036 complaint. It wasn't even the exclusive remedy that he had to oust his purchaser, which was the only remedy was ejectment, where title could be tried. So there's big problems, and the purchaser status is highly relevant to the state law and U.S. constitutional arguments. So there you have it. 9 weeks after the irreparable harm, the catastrophic damage to Gulliver, walking us off the property we were purchasing that we lived on for 7.5 years. And 9 weeks later, we still have not had a due process post-deprivation hearing from anyone. Now, the Honorable George M. Wright, surely he must have had some background education in constitutional law and pre-deprivation and post-deprivation due process hearings. And if he is correct in his orders about what he says, well, number one, no squatter complaint in the state of Florida could ever be examined for perjury, contrary to the squatter statute, which would insulate every perjurer who wanted to be a predator on the victim of a squatter complaint. Number two, if he has no jurisdiction and it's not justiciable, when almost anyone with a law school education would, because of their legal training, would file an answer, and then they would be said to be suing themselves, then there's big problems because you're blocking the mandatory, expedited, timely, and meaningful due process post-deprivation hearing. So is Florida's squatter statute unconstitutional? Well, 9 weeks and we have not gotten the post-deprivation hearing that the statute says we're entitled to have. So I'll just leave y'all at that. And I did this video because of my next video, which is going to go into the catastrophic harm that this has caused. And so that's all for today. Thank you for watching.